All rise.
Before my friend resumes, can I just tell the court that my client has come to court this morning with a copy of the decree absolute in her divorce proceedings.
Thank you very much. So,
Having been reading District Judge Brass's judgments overnight, it did cross my mind that there might not have been a recognised marriage to be dissolved, but fortunately there was.
Well, yes. My instructions as to the children order is there was no order in respect of Q in the matrimonial proceedings because of the concurrent public law proceedings, although there was the relevant certificate under section 41.
yes. So, can you make copies of that?
I will.
That
We will have
document
that.
available?
We will
Thank you
do
very
that. We'll
much
do that,
indeed.
my lord. Yes.
What's the date of it?
4th of August 2004.
Thank you.
Queen Eyesight the 17th of June. The decree absolute 4th of August.
Yeah. Thank you.
Could I also ask something else about the papers? We have got the two one is the fact-finding and one is the reviewed fact-finding
Yes.
judgments of District Judge Brass, but there clearly was a third one.
Third judgment.
Yes, in which
On the occasion of his
making the
Ross
order
Worth
and
order.
making the residence order.
Let me have a seen a transcript of that judgment.
Well, it would be very, very helpful, obviously, as part of the background, to see what he was thinking when he made the residence order that he did,
Yes.
if it's available.
Well, we don't think that has been transcribed.
No, well, fairly clearly, his second judgment, except that there's a reference in Mr. Justice Headley's judgment in 2004, when he authorised removal, to 3 judgments by District Judge Brass, which rather suggests that there is something sitting somewhere.
We will make inquiries with
Yes,
him.
thank you. It's only background, but it all helps.
Of course.
Right. Now, Miss Russell.
Thank you very much
We were looking
indeed.
at third state.
I was looking at third state, but I wonder, with your permission, my lord, and that of my lady, if I could just return briefly to the matter of District Judge Brass's second hearing and his second judgment. My lady mentioned yesterday that she, I think, suggested, and I hope I'm not putting words in my lady's mouth, that she was somewhat surprised that it was not by way of appeal but by way of rehearing. And I thought maybe some explanation may be helpful to the court. It's not at all unusual in care proceedings. It's not common, but it's not unusual in care proceedings for there to be a rehearing if fresh evidence arises after the first fact-finding. And indeed, it's common that that is dealt with by way of rehearing, either by the district judge or the circuit judge. There's similar provision in the High Court. And just for the sake of completeness, I think it may be helpful to refer the court to the civil procedure rules, that is to say the County Court rules, Order 37, Rule 1. And if the fresh evidence reaches what I may describe as the Ladd and Marshall criteria, the case will almost always be reheard by the same district judge or the same circuit judge. The only exception usually would be if the judge was criticised, then it would be considered inappropriate for that judge to rehear it. And it happens frequently.
Are the county court rules still in operation?
Well, yes. Sorry. In some respects, yes, they are.
But this is still in operation,
yes,
is it?
yes. I looked at it last night. And there's similar provision.
What does it say? Forgive me, what does it say?
I haven't, forgive me, I haven't written down its precise details, but as I said, it's common practice, and there's similar provision in the High Court, which arises from the Supreme Court Act 1981, Section 17. Lady, I'm just, and my lords, I'm just pointing that out because I thought there was some concern raised about the nature of that hearing, and I wanted to try and set before this court the fact that this quite often happens, because fresh evidence is quite often forthcoming after a fact-finding here for many, many reasons, some of which I think are pretty obvious.
What are the mechanics? I mean, how does it come back to the
Well,
the
what
judge?
happened in this case, and what normally happens, is that an application is made to the court for a rehearing, and in this case I understand, although obviously I wasn't involved at the time, that such an application was made by those representing the father, first respondent, the local authority who was obviously involved in the proceedings at the time, and the guardian's representative, because of the fresh evidence, which you will have seen alluded to in District Judge Brass's, as he then was, his second judgment.
I didn't see anything in that judgment which addressed his mind to Ladden Marshall.
Well, I don't think there isn't. But what I'm saying, milady, is that I'm not trying to give evidence, but as a care practitioner, there are many circumstances that I can think of and that I've experienced where such a thing has happened for obvious reasons.
I can quite understand why it might. I am concerned that family practitioners.
Sorry, I beg your pardon.
I am concerned that family practitioners, from time to time, do the sensible, practical thing rather than the thing that is entirely correct in accordance with legal procedures, which is why I raised the question in the first place. And I became even more concerned last night when I read the two judgments. Yes. And so it's obviously something that it's a background point in this case, but nevertheless, all of these background
maybe
points.
We can provide you with the relevant county court rule and the case of O'Connor and Dinn from 1997, which is reported at 1 Family Law Reports 226, and we will provide the court with a copy if the court would find that helpful, where it's proposed that the challenge of a decision of the county court because of fresh evidence, the appropriate course, and that's a Court of Appeal authority, the appropriate course is to apply to the court under the county court rule that I've already referred the court to for a rehearing rather than an appeal. So it's not based on pragmatism, although I completely accept what my lady says about family practitioners' reliance on the pragmatic approach.
What was the date of that decision? Sorry, I missed it.
1997, and the report that I was looking at last night was 1 Family Law Reports 226.
Yes.
And if my lord would find it useful, we can provide the court with a copy of that decision.
And that's a Court of Appeal decision?
That is a Court of Appeal decision, and that's certainly what's followed. And as I said, there's similar procedure that's followed in the High Court. An application is made for rehearing. But there are not rules which provide for that. The only provision at the moment is the Supreme Court Act 1981, section 17, subsection 2. And again, if the court would like to have that, that can all be provided. And I apologise for not having it now. I just thought it would be helpful by way of background information.
I'm sure we can find it.
Thank you very much, my lady.
But we don't have a copy of the application, do we?
No, we don't. And I don't know if there... certainly... I haven't seen one in the documents that I have seen from the previous proceedings.
I mean, the way that it comes over, just reading the judgment,
I know,
that's all I have. The way that it comes over is he has a split hearing, he hears the evidence about the injuries and draws his conclusions about who caused them. He then, of course, puts it off for the usual further inquiries in order to work out what's the right answer to the way forward. And at that next hearing, he decides that he's going to review his earlier
Well,
findings.
I fully understand Milady's disquiet, particularly after reading the judgment, and indeed that is how I, in many ways, read it myself when I saw it myself. But I understand that that's what's happened, and I felt it was appropriate to draw to this court the authority and for rehearing, which positively suggests that rehearing is in fact the correct way to deal with this situation.
The father was unrepresented, wasn't he, at the time? The father was unrepresented at the time. Is that
No, he was represented.
Oh, he was at that stage.
And at that time, during the care proceedings, he, as I understand it, there was an application made partly on behalf of the local authority and others, but not by the mother, for a rehearing because of fresh evidence that had arisen.
Yes. No,
That's not surprising.
Not at all, no. And it's not unusual, and it's absolutely not unusual for, as Milady knows, for fresh evidence to arise after fact-finding.
Well, it's one of my reasons for disquiet about split hearings.
All kind.
But I asked my question simply because one can understand that accidents would happen if people are not represented, but it's a little more disturbing if they were represented.
Well, the situation, as I understand it, and the reason I'm speaking is so that I can be corrected if I'm wrong.
Yes, of course, yes.
Is that the judge made his findings as to what he thought had happened. And the next stage normally is that there is then assessment of the parenting capacities of the parents.
By experts.
By experts, in order to work out what the right way forward for this
risk assessment,
little child is. It was as a result of the experts engaging with the case.
That's exactly
that
right.
They took a different view from the judge as to who was the more likely perpetrator of these injuries.
Exactly. And concerns were raised by the experts as to the perpetrator of the injuries. And as a result, the local authority felt it proper, but supported, as I said, by the guardian and by the father's representatives, to invite the court to rehear, and that's what the court did. And whether there was a formal application or whether it was made orally at the beginning, that, I'm afraid, I don't know. My learned friend, my junior mate. There was no written application. There was no, I beg your pardon, my lord. There was no written application, but there is a legal basis for it, and it's considerable.
Yes, but it is unfortunate, is it not?
Well, Milady, I just feel that it may be unfortunate, but it's not without a proper legal framework, and that the court may.
Yes, but of course, if a proper application has to be made,
well,
then the proper legal framework will be addressed. It may be that it was perfectly all right in this case. I know not, of course, because I've not seen the evidence.
An application was made, but it was oral, and I can't comment on whether it covered every aspect.
Is O'Connor's widely known, is it? I mean,
I have to say that it's widely known, yes. I mean, I'm involved in several such cases myself, and it has happened. I've even heard them. I mean, it has happened, and it does happen because there are so often fresh evidence arises for many reasons, including people changing their mind about the evidence they gave in the first place.
I mean, this appears to be down to as the judge put it at paragraph 6 of his second judgment, a change in the information given by the parents to the
experts. Yeah, that's what it was.
Presumably, if these points had been live, they would have been ventilated at the subsequent attempts to appeal this part of the case.
That I can't comment on, but I'm sure that they were. I mean, I can't imagine for 1 minute that
don't let us engage any more time.
No, I'm sorry, my lady. I was trying to be
the worry that I had about the way in which this case had developed previously. It's all water under the bridge now.
Well, shall we go back to third state?
Yes, please. Thank you. And I thank you for indulging me with that particular part. What I would like and would ask you to do, my lords, and my lady, is to look again at the precise use of the phrase within the regulation itself, because it is this regulation and its interpretation with which this court is concerned. And at the risk of what may seem to be real pedantry, I would like to start, and I hope not to take too long about this because my lords have already heard so much about it, by looking at 12.4, where the phrase itself arises. The territory where the child has his or her habitual residence in the territory of a third state. And the piece of pedantry that I am indulging in is asking the court to look at the fact that state has a capital S. Now, if I could go back to the fact that it's clear from the use of language in copious amounts of commentary and literature that third state, that's to say small t, small s, is used constantly to mean a non-contracting state. I accept that on the face of it, this language would, without more, read as if third state here means non-contracting state to this regulation and indeed to the Brussels Conventions generally.
It's one of these problems that one has, in my own experience with law reporters. If I use capital S for state, they tend to strike it out and put it lowercase. There's a sort of house style. And my impression is, I may be wrong about this, but my impression is that when you get a council regulation or any EEC document, state always has a capital S. But is that wrong? I mean, I mean, you were suggesting that if capital S belongs to people who are within the EU and anybody outside it gets a small s.
That is what I'm suggesting. I'm suggesting, but I'm not suggesting it in any way in a facetious manner. I'm suggesting it within the context of this regulation. Yes. And I intend to use, if I may, further example of what I say third state means within the context of this regulation. Right. But I do think, because even whether or not there's a house style, and I accept that there is, but whether or not there's a house style, there is also care taken in drafting. And I do not think that it is by mere happenstance that S has a capital, that state has a capital S. I think it's because, and we would say it's because it refers to a third member state. And the reason that I say that is that we would say, for example, in paragraph 2.4, that this is a provision which introduces a qualification which is what should be considered to be in the child's interest, the presumption being that if the member state in which the child is habitually resident is not a contracting party to Hague Convention, then it's presumed to be in the child's interests. It's presumed to be in the child's interest for the country favoured by and agreed on by the parents, because the only use throughout this document for third state on the construction that is being put to you, my lords, on behalf of the appellant, is that there is one situation where this regulation would apply to non-contracting countries, and that is if the parents or the parties choose that it should, and in no other circumstance would it apply to third countries or to non-contracting countries, if I can use that term. That in itself, I think, is a curiosity, but I think that what we're trying to suggest to you is that if you look at the construction of Article 12 in its entirety, the parties that are essentially referred to are parties, first of all, to a marriage and parties who are parents to a child upon which some decision is going to be made with reference to parental responsibility. Now, we would say that if it would not be unusual or unheard of for the parents to be living in separate states themselves, and that there may be 3 states involved, and that it is for that reason that the 3rd state is referred to. So, for example, and I mean, one can only give examples, the parents may both live in Belgium, the father may spend a lot of his time in France, and the child may live with grandparents in Germany, and they choose France to be the country that they want the matter to be heard for matters of convenience or matters that are important to them. They choose it. They choose it unequivocally. They go to the court and say, we wholeheartedly want this court to deal with it. And that is where the 3rd state comes in. And I would say that Article 6.1, if you accept my construction of 3rd capital S state, supports what I'm saying.
What are the situations on your approach where there could be a 2nd state as opposed to a 3rd?
Well, I think that if it's a 2nd state, it means just the state that the child's living in. In other words, the child who is not a party to this or these discussions between these parents, because child's not represented or isn't deciding which jurisdiction. I think it's allowing for the fact that there will be cases, and may often be cases, particularly in Hague Convention cases or abduction cases, where there are 3 states involved. Say, for example, if we look at Article 61, where a parent removes a child from territory A, country A, to territory C, to territory B, and the child's habitual residence is actually in territory C. That, I would say, is what Article 61B is referring to when it talks about 3rd states. And I can see, my lords, that some of you are looking quizzical about that, but I will return to why I'm saying.
I may plead guilty to looking quizzical because if I've understood your argument correctly, you're saying that the word 3rd is used to accommodate the possibility that there will be 3 states involved. Is that right?
Well, to accommodate that possibility and to point out that it's a state that is outside the one that one would normally look at, which is, the state that the child is living in. That is the presumption that you start off with, the state that the child's living in.
Why
the parents
choose the word
live
3rd instead of the word different?
Well, I don't know why, but I am saying that is what is meant here. And the reason the S is capital is for a reason, and that is that throughout they're talking about member states' capitals. And the 3rd state, and I think it's particularly noticeable if one looks at Article 61, which is dealing particularly with the recognition of judgments or the enforcement of judgments in relation to the Hague Convention. And in that particular situation, what I would say is the use of 3rd state in this sub-paragraph means, I think, what I've already tried to illustrate, that when a judgment is given in member state number 1, in respect of the territory of member state number 2, that judgment will be both recognised and enforced even if the child has his habitual residence in member state number 3, which is also a contracting state to the Hague Convention. In other words, member state number 3 is a contracting state to the Convention, but regardless of whether or not member state 1 where the judgment was made was a contract contracting state to the Hague Convention.
But why restrict it in that way? What's the rationale for restricting it in that way?
Well, if it's not restricted in that way, and this is the second part of my argument really, my Lord, is that if it's not restricted in that way, then the restriction is this: the only time that this regulation can apply to non-member states or third states or whatever one wishes to call them, that are they're not members of the European Union, is when the parents choose it. And at no other time will that regulation apply.
What's odd about that?
Well, I would suggest that it's not odd, but it's incongruent to suggest that it would apply in that situation, but it wouldn't apply, for example, under Article 15, where the court is looking at which court would be, and if I just turn to that and ask you to turn to it, the transfer to a court better placed to hear the case. Now, it's absolutely, without doubt, easy to imagine that the court which was best placed or even better placed to hear a case may be a court that is not in the European Union. Yet there is no provision in Article 15 for the court of its own motion to transfer the case, even if it's the most obvious place for the case to be heard. And it's the incongruency set against the entirety of the regulation, which I alluded to yesterday, and I've alluded to in my in our document that's filed with the court, which is to deal with the internal market of the European Union, recognition and enforcement of judgments within that area, and the facility of the legal framework to facilitate the free movement of people, including dealing with their family lives.
Does one not have to bear in mind, looking at Article 15, the point that we discussed yesterday with Mr. Baker, that this really is an exercise of jurisdiction? In Article 15, the court is a court which, otherwise, if it didn't transfer, would be perfectly competent to exercise jurisdiction. It's not the sort of thing a court can do it if it has no jurisdiction.
Yes.
So one's got past Article 12 by the time you get to Article 15, and I'm not quite sure how Article 15 can really help you on understanding what's made by a third state in Article 12.
It seems, if I can elaborate what I'm saying at the moment, my Lord, I think it might explain what I'm trying to say about the incongruity of Article 12 being the only situation in which it would be considered apposite for parents to choose jurisdiction, even if the child is not living within that jurisdiction. And that is that part of the raison d'etre behind the regulation is the enforcement of judgments and the recognition of judgments. And if parents choose to deal with a country, whatever the country is, be it Pakistan, be it the United States of America, be it the Ukraine where the child lives, be it Jamaica. I mean, one can think of many countries that have very close connections with this country where children quite often live long-term with extended family members, either after public law proceedings or within private law proceedings. And the parents choose that country, this country or another country within the European Union to be the jurisdiction to hear the case, when it's patently obvious that the other court may neither recognise the judgment nor enforce it. And how that supports the generality and the specific desire of this, or aim, I think is the proper term, of the regulation, which is also set out in the guidance, is hard to explain and I think is incongruous. Because even if enforcement is not the main priority, it's certainly a priority. And for parents to be able to choose not to have a case heard where their child is living and nothing can be done about the result, whatever the result is, even if it's the right result in inverted commas, seems to be totally outside the aims of this regulation. And I'd ask you if you would.
But it's all subject to the an ultimate decision by the court as to what is in the best interest of the child.
Well, not according to the proposition that's put forward on behalf of the appellant, because the best interests of the child may not coincide with the unequivocal agreement of the parents that the case should be heard here, and the court may be ignorant of or not fully informed about the reasons for the case not being heard here or in another EU country. So it's not...
Doesn't the court have to apply its mind to the third of the hurdles in
the interests of the child?
3B, yes.
Well, if the parents say it is in the interests of the child, these are the reasons why we say it's in the interests of the child. We unequivocally, both of us, ask that the court hear it. The child later comes along, or perhaps the child and a carer come along and say, no, it's not. They've left out this, or time has passed and that has happened, or, you know, they're glossing over some of the
This is where we get to Mr. Baker's solution to that.
Which is?
Which is that the court can decline to make an order.
Well,
And
it seems to me that either the interest...
Assuming that's not contrary to the principles in EWCA, as to which said query, but assuming it's not, then that would be a solution to it.
Yes, and as far as EWCA is concerned, again, I would suggest that it's an exercise of jurisdiction as opposed to declining it. And I mean, you would say no order, having considered the situation.
Well, I would have to look at EWCA to see if that's really right, but on that assumption...
I mean, that's a possible argument. Anyway, you see, I can't ignore the very last line of paragraph 4, which is lurking at the back of all of this, that you may reach a situation where the third state, it's impossible to hold proceedings in question. It's rather unlikely that would be true of a member state of the EU. I mean, it may suggest that what's really being looked at are places very far away, of which you know little.
But I don't think impossibility is just talking about legal impossibility. I think impossibility is talking about practical impossibilities or factual impossibilities, and to limit it to legal would be wrong.
Well, it's more likely to be a practical problem, isn't it?
Well, indeed, and one can see where there may be practical problems. It may be highly practical to hear the case where the parents are both living because there are issues concerning the parents alone. Or it may be impractical to hear it in the case in the courts of the country where the child is living for practical reasons too.
Yes. Well, can we gather the points together? I mean, I see that one point which you began with is the capital S point, and then there's the numeral point. There's the third point, the third, which you say is a guide as well. And, and then you're making the general point that it seems contrary to. Am I putting this too strongly? Contrary to principle or common sense that parents should be able to just make this choice, as it were, for the child, and the child comes in later, and if Mr. Baker's right, the pass has been sold. And you say that seems quite unfair. I say
that is also not in keeping with what seems to be set out in the regulation itself, particularly at paragraph 19 of the preamble.
This last point about parents making the choice for the child, which is a very understandable point, because that point as a policy point would apply equally to a choice between member states.
It would, but my additional point, and I don't think my Lord came to that is that I think it is really truly, and we would argue it's incongruent with the aims of the regulation to be contemplating reaching judgments. I mean, I accept that courts can make no order, but there seems little point in hearing a case when one can see quite clearly that one is either going to make no order or one is going to be unable to enforce the order that one makes as a result of one's decision. And if I could ask you to look at page 17 of tab 2, which is the guidance, and looking at Article 12.3. First of all, I'd ask you to look at that. Again, the only reference there is to a third state that's not a contracting state, to the, I'm looking at the part that's headed Article 12.4 in bold.
Sorry, which page?
17 of tab 2, my lord.
Yes.
Now that's looking at Article 12.4. And it is setting out what I would say is the qualifying provision that the child's best interest will be presumed to be when the child is habitually resident in a third capital S state that's not a contracting state to the 1996 Hague Convention. Now, again, I say that when read in the continuum of the entire document, it's referring, again, it's the capital S point. But
is there an example of a small s
not
state
in this,
in either the regulation or
not
the
in
guidance?
This, no. I mean, I've looked through it, and there is not. The only, and the third point that I'm going to come to in due course is that where the regulation, the regulation that we introduced into the argument, the most recent regulation, which is looking at making bilateral agreements, is concerned, the term third country is used throughout.
Country with a small c.
Yes, meaning any country in the world. Or, in this case, I would say that the states have a capital S because it means not any state in the world, but a member state, a third state.
If you do a search
I
on...
can see that, my lord, that you are not taken by this argument.
If you do a search on Westlaw, third state in the EU section, I didn't get any further than finding that there are 1,000 mentions.
My lord, I have
and as far as my recollection is, everyone had a capital S.
But
the first
there are
couple of
also
pages.
many references to third country where it's clear that what they're intending to mean. I think it's unfortunate because basically part of my argument is that third state is used in both situations, and that what I'm trying to say really is that it is wrong for it to be used in that way within the context of this regulation.
Can I go back just for a moment to,
Yeah.
to Article 61?
Yes, of course.
And ask you a question which I think I asked yesterday, but I want to get a clear answer from you.
Yes. I apologise if I didn't give you one yesterday.
Well, if you're right on the meaning of third state in B,
Yes.
would Article 61 be any different if B altogether were not there?
Yes, I think it would be.
What does it add?
Because I think that if B weren't there, it would mean that if the child was living in a third state and it was a non-contracting member to the Hague Convention, the interests of the child would be taken to be from Article 12.4, the only other place that it's mentioned, to be that the child...
Yes, but B is talking about recognition and enforcement of judgments. So A says, the effect of A is that, as concerns the relationship with the Hague Convention, this regulation shall apply when the child has his or her habitual residence on the territory of a member state, and therefore all the recognition and enforcement provisions would come into play there.
I think that is there to deal with, and no doubt I'll be corrected if I'm wrong, but I think that is there, and I'm suggesting very strongly that it's there to deal with cases of abduction. And they're saying
this
that
isn't
even
about abduction. This is about recognition and enforcement.
But I'm trying to.
But it's not
explain,
about abduction.
Milady, if I could finish trying to say what I'm trying to say.
Well, it might help if you finish listening to my Lord's question before you tried answering it.
But the point is that this is about the relationship with the Hague Convention.
Yes.
And on your interpretation of B, it says that if the child is habitually resident in another member state, which is a contracting party to the Hague Convention, this regulation applies. Mm-hmm. But A already says it applies.
No, it doesn't. It says that it applies where the child has his habitual residence on in a territory of a member state, and makes no reference to the whether it's a contracting member of the Hague Convention or not, and that's the difference. And I know this is not about abduction, my lady. I'm very clear about that.
B subtracts something from A, because A seems so general. A, just a member state, unqualified.
I think that what it's meant there is that if the Hague Convention and the regulation have two different aims and have different outcomes if they're both followed. And what it's saying is that if a decision's made in country one about country two, regardless of the fact that the child living in country three may have there may be different outcomes on the application of the Hague Convention, the regulation, the judgment of country one would be both recognised and enforced. It's about the operation of the Hague Convention and the difference that may make if the child is living in that country and two other countries, maybe one who is not a contracting member to the Hague Convention, make a decision. Yeah. Well, a decision's made about one.
But if it means a non-member state, then it does begin to make sense, because it's telling the member states that if the Hague Convention would lead to a different result as regards recognition and enforcement, then Brussels II revised trumps it.
It is saying that, yes. But I would say that it's saying
more than that. And are there some practical examples of that? What would be an example of that?
An example of?
Of the position being different under the Hague Convention.
A specific example. Well, if the child is resident in a country that's a party to the Hague Convention, then the provisions of that convention would apply. If the two other member states are not parties to the Hague Convention, then there would be some presumption in the third country that the Hague Convention would apply, would trump the decision made in the first country, which was a non-contracting state to the Hague Convention. My Lord, if I may move on and move back really to the regulation itself, and if we look at the guidelines to Articles 61 and 62, which are at page 45 of tab 2. And I think perhaps answer in some way the question that I was just asked by my Lord Clerk. This is looking at the juxtaposition between the enforcement of orders under the regulation or under the convention. And question C is, does the case concern the recognition and or enforcement of a decision issued by a court in another member state? And goes on to describe that it's irrelevant whether the child concerned lives within the territory of a particular state, so long as the state has competence to make the decision. Hence, the rules on recognition and enforcement of the regulation apply to decisions issued by the courts of a member state, even if the child concerned lives in a third state which is a contracting party to the convention. The aim, and this is the part that I would ask my Lord and my Lady to pay attention to, if they are in any way following the argument that I'm trying to make, and that is that the aim is to ensure the creation of a common jurisdictional area which requires that all decisions issued by competent courts within the European Union are recognised and enforced under a common set of rules. And that is the aim behind the totality of the regulation. And it is that incongruity that I'm suggesting is seen in Article 12.4 in particular.
The third state in the last paragraph must be a non-member state, mustn't it? Or include a non-member state.
Well, even if...
In the guidance note, I mean.
Yes, yeah. But even if it does, that is the aim is to ensure the creation of common judicial area and to decide matters on the behest, for example, of parents. And it may not always be of parents, but it will usually be of parents because they choose a country within the EU to look at questions regarding their parental responsibility of a child that's living outside the EU is not in keeping with that aim.
Do you accept that, the second last sentence of that paragraph on page 45?
No, I don't, because I say throughout that third state means state of the Union, member state of the Union. But even if it did, I would say that it is not in keeping with the aim of the regulation, and that's not what's meant by it. Therefore, that's not what's meant by it.
So your position is, first of all, that it doesn't mean a non-member state, but that if it is, it's wrong.
No, sorry, my lord. What I'm saying is that that third state there means what I have argued throughout that it said.
But the difficulty of that is it doesn't really, the first sentence doesn't really make sense on that basis, does it? The first sentence of the last paragraph.
Well,
it doesn't say the member state in question.
I say that, no, it doesn't.
It says a member state.
I say that it does make sense because you may well be dealing with more than two states and often could be dealing...
I'm just focusing on the language. I can see that the law could be different. And the difficulty about the last sentence of the previous paragraph is that the question we're on is part of the analysis of what the competent court is. So if your argument is wrong, then there's nothing inconsistent with the last sentence of the previous paragraph.
Well,
it's just that the notion of the competent court is rather wider than you would have it be.
Yes, but the question that's being answered is, does the case concern the recognition of does the case concern the recognition and/or enforcement of a decision issued by a court in another member state? And so I say that that means that third state is talking about a member state because it's answering that question within the context of the guidance.
But why on earth would they use the expression third state as opposed to another member state? As my lady pointed out, the indefinite article qualifies member state, the territory of a member state. But it applies also when the habitual resident of the child is in a third state. If that is designed to identify another member state, it's an extraordinarily bizarre way of doing so, isn't it?
Well, not, my lord, if you accept what I'm saying, that it will often be more than two states, or it certainly has to allow for that possibility when one considers...
I see, it's the numerical argument
yes,
in this case.
Well, we've
Shall I move
gone
on?
over the ground fairly thoroughly now.
I'll move on. I'd like to move on, if I could, to the question of equivocal consent.
Yes, so we're back to 12. And
Yes.
we're looking
Well,
at,
if my lords are not with me, I have to deal with that question directly.
yes, so this is unequivocal manner, basically. Is
Yes.
it? It's that phrase in 12.3b.
Yes.
Thank you.
And we have to accept, and do accept, obviously, that the first respondent has attended at court, he's participated in proceedings, he's made one application which you've been referred to be released from his undertaking, and he has, on the face of the document at tab 20, to which you've been... I'm sorry.
Tab 20.
Sorry, I do beg your pardon, my lords. And he has been, he's expressly accepted jurisdiction, as I've said, in the document at tab 20,
Yes.
to which you've been referred to on several occasions. I won't take you through all of it, but just merely refer you to paragraph 27. 26, I beg your pardon, at page 5 of that document, in which he expressly says that the court didn't have jurisdiction under Brussels II revised. But nonetheless, it has to be said that he has participated in the proceedings, he's attended at court. I would ask, however, that the court consider whether his participation, the manner of his participation, can be equated with unequivocal consent. And this is how I would put it. Mm-hmm. I would start by saying that he has attended court on at least 3 occasions when he was ordered to do so, rather than because he was seeking the jurisdiction of the court to be exercised himself. And he attended court on those occasions, and they can be seen by the orders that were made by the court. First of all, at tab 28, which is the order of the 31st of October 2007, in which it was made plain, and this is a very common order, of course, that if he did not attend, an order could be made in his absence.
So that was the mother's application which was being heard. And
the origination of these proceedings.
Yes.
Or as the appellant would have it, when the case was seized with the proceedings. Then we have an order at tab 37, dated the 1st of December 2008, which is an order of His Honour Judge Turner QC, that if he did not attend, an order may be made in may again be made in his absence. Sorry, I've given you the wrong reference. May I refer you to that? It's not the order of His Honour Judge Turner It's an order of the principal registry regarding further directions, which in fact was the case that was heard by Mr Justice Headley in June. But prior to that hearing, at tab 33, there's the order of His Honour Judge Turner, which is dated the 24th of April 2008, when he was ordered to attend and a penal notice was attached.
Was it the 24th of April or 15th?
Tab 34, sorry.
It's listed for the 24th. But
I'm not sure if it's dated the 24th of April.
This is tab 34.
Yes.
oh, I'm sorry. Yes, I see.
I think you said tab 33.
34,
District
yes.
Judge McGregor.
Yeah.
Is it? Sorry, I thought
No, the 24th of April order of His Honour Judge Turner is the one with the penal notice
That's right.
attached, and
Yes.
that's behind tab 34.
34, yes.
Yeah.
I'm sorry.
But that order records that your client didn't attend, did it?
Yes, but the reason that I'm drawing attention to you is not that these are unusual orders in any way, but they are putting an onus on him to attend, and I think they indicate at least an ambivalence on his part about participating in the proceedings or seeking to have the or accepting in full the jurisdiction of the court.
What about...
So I have to say that we would have to accept on the face of it, he has accepted the jurisdiction of the court, but we would say that that acceptance, sorry, my lord.
Well, I was thinking of what happened on the 4th of March, 2009.
When he filed the document that I'm referring
Well,
to.
his application, wasn't it, to set aside
His
Mr. Justice Headley's order?
undertaking, yes. I'm sorry,
So
my
I'm just
lord.
correcting the other when she says the application was to set aside the undertaking. The application was to set aside the order made by Judge Headley in June 2008.
Yes, that's
And
right.
to be released from his undertaking. It doesn't say that in the document. I'm sorry.
What is the date at which we're testing these questions?
Well, we're testing them from the beginning of the proceedings, which started on the 31st of October 2007.
Yes.
And I have to accept, and I do accept...
I'm sorry, we're testing it as at the 31st of October. How is what happens after that relevant?
Well,
It depends
he
when...
wasn't there on the 31st of October, so it's impossible to say that he accepted the jurisdiction of the court. He wasn't even at court on the 31st. That's why there's an order saying he's to attend court or a...
The reason I ask is that I suppose this depends upon what's meant by at the time the court is seized. But if the at the time the court is seized means first seized, then we would be focusing only, would we, on the date, on the...
Well, the court may be seized with the matter as soon as documents are filed, but that does not imply unequivocal acceptance,
No, I
does
wasn't
it?
suggesting it is. I'm just trying to find out... Well, first of all, what is your case on at the time the court is seized in little b?
Well, I'm saying he didn't accept
No, I'm
it.
just asking...
There's
First of all, I'm just asking what your case is on the construction of paragraph 3b as to the
I'm
meaning
sorry, I
of the
beg your
expression at the time the court is seized. Because that is the critical time for deciding whether or not there's an unequivocal acceptance, isn't that right?
Well, I would say it was when it has to be when both parties have had an opportunity to express their acceptance, unequivocal or otherwise, so that it would be the first time that the court has had the party is seized of the matter in the sense that the case has begun because papers have been filed.
So when was that?
Well, the first time that he attended was the first hearing after the 31st of October, and I think
it was on the 5th of November.
Yes.
The order made is on the behind tab 29. And that adjourned it to a conciliation hearing, which he attended. And that conciliation hearing resulted in a conciliated order.
And at the time, I would say that his acceptance was not unequivocal.
I quite follow that, but just this prior question, I'm just quite anxious to get quite clear in my mind what your case is on the prior question. I mean, are you saying that do you accept, for example, that there is a moment at which the time is only one moment?
No, I don't.
Of time.
I don't accept that. I don't think that it would be possible to hold parties, particularly parties who have difficulty with language and who are in person, as being having unequivocally.
No, but that's a different point as to. I'm just trying to find out what is meant by the word "at the time the court is seized" in Article 12, paragraph 3b. There are two possibilities, as I see it. One is that it identifies a moment.
I see.
There's scope for argument as to when that moment is. A second theoretical possibility is, at least, that it encompasses the whole of the time over which the court is seized, in which case an unequivocal agreement at any time during that whole period would presumably be sufficient. But the case on the other side, I think, is that at the time the court is seized identifies a moment. So in order to, the first question therefore is you accept that we are looking for whether you accept.
No, I don't accept that we're looking for a moment.
In which case,
I think it's
your
difficult.
case is then, is it that your case
Yes,
is
I
that
say
if there's
that
an unequivocal agreement at any time during the whole period during which the court is seized, then that would be sufficient for Article 12.3b. Is that right?
I'm saying that the court has to look, once the court is seized as a matter at the beginning, which is in the sense when the proceedings are started on paper and the matter is filed, the court is seized of it then, but the court continues to be seized with it. And there are two reasons why I'm saying that one has to look at the continuance of the season of the court. The first is that one cannot glean unequivocal acceptance unless it's expressly made, and that's something that I'm going to have to deal with separately. And also because it says all the parties, and it is very common, certainly in children cases, for children to become involved if there have been, for example, public law cases in the background, such as there are here. And it is those kind of cases where there would be children living in non-European Union countries as well. Those are the kind of cases that we're looking at within the context of this case.
But does that mean that the court can't know or can't determine whether it has jurisdiction until the child is
I think that the court has to be able to revisit the question of jurisdiction within the context of 12.3. So, for example, if all the parties at the beginning of the case are the mother and the father, but it's clear that the child could or should become involved, it cannot be right that the court itself is not able to revisit the question of jurisdiction, considering...
If I may just ask you something about that. Does that mean that if the parties understand the implications and unequivocally give their consent to jurisdiction, that the court then has jurisdiction?
The court has jurisdiction, but it can revisit the question
But when you say revisit the question,
On the basis,
if a further party to the proceedings intimates a lack of consent, do you suggest that the court thereby loses jurisdiction?
yes, I do.
I see.
So this is a separate point from the point you already made about best interests, because that third hurdle, you say, is open to review
Yes.
when the child
Yeah.
becomes a party.
But I say that it's part of that because it's based on what is said in Article 3B. The jurisdiction of the courts has been expressly or otherwise in an unequivocal manner by all parties to the proceedings. And at the time his court is seized, I'm saying is the continuance of the case and is in the best interests of the child.
How does that fit in with Article 19.2?
That's hearing what the child has to say. And sorry, I beg your pardon, 19. I don't think it conflicts with Article 19.2.
Well, it definitely has the concept of a moment in time when the court is seized.
Yes,
and so does Article 8.1.
Yes, I accept that it does,
And so do many provisions of the Brussels Conventions on different
Article
allied.
16 as
So
well.
does Article 16.
16 is telling you, giving you some kind of guide as to what it meant, and it's looking at particular events.
Well, you have to say something else as well, don't you? I mean, as well as this time point, you also have to say that, well, you may not have to say it, but you may wish to say it, that even if somebody has given their consent, they can later withdraw it.
Well, I think that would be a proportionate act to be able to follow through. And the other thing that I think...
Otherwise, you've got this problem.
Yes,
that
indeed.
on legal advice, expressly, your client submitted to the jurisdiction. So you have either to say, well, that doesn't mean what it says, or you have to say that he's entitled to withdraw that.
I think that he is. I mean, he expressly said that Brussels 2 didn't apply, but that's perhaps not a very attractive argument because at the same time he
An argument
accepted
within
it.
jurisdiction.
Yes, quite.
But I think your answer to the moment in time point may be, if I've understood your argument correctly, yes, there is a moment in time, but a second moment comes along when the child becomes a
Well, I
party.
think that must be right. I think that it's right because it's proportionate, and I think it's in keeping with what they say, what is said at Preamble 19, which is that, you know, that what the child has to say is important. I mean, I'm paraphrasing, obviously.
What becomes of the orders that the court have made while it has jurisdiction? Are they still effective?
Is my Lord concerned about the orders that were made in the first place in this particular case, or just generally?
I'm not too worried at all about either. I just want to know what your view is.
I think it would have the orders that were in existence say if the child's representative, or perhaps the child's carer and child themselves became parties to the proceeding and said, we don't want the case to be heard here, we don't accept this, we are a party, all the parties have not given their unequivocal acceptance, which is what they would be saying. The previous orders would no longer be in force because the whole case would have to be dealt with in the jurisdiction of the child's habitual residence.
So they become a nullity in effect.
In effect.
Yes.
Even if...
But in this case, the orders that originally were made when the child was removed to Pakistan were, of course, made under completely different circumstances because the child...
And you're saying that the orders, the previous orders on the hypothesis as put to you, would be nullities,
Yes.
and that's even if there had been unequivocal express acceptance of jurisdiction by the parents.
Well, yes. I mean, it's no more stringent than saying that the child and or a carer would be bound by the jurisdiction because the parents had chosen and they happened to come along later.
Anyway, your position is that as far as the first part of the situation is concerned, this isn't a case of
Unequivocal acceptance. That's what
either
I'm
expressed
saying.
or otherwise in an unequivocal manner. So you say that actually
And that's
the test
where
was never satisfied anyway. Is that
Yeah.
your position?
Yes, that is my position. And I'm saying that, first of all, I rely on, and I have no argument with the analysis by Lord Justice Thorpe in the sense that the court has to look at the continuum of seizure because there are times when it would be, and I absolutely accept that it would be disproportionate and against any suggestion in any part of this regulation that one could change one's mind in a capricious manner regarding jurisdiction having accepted it in the first place. But if there is good reason to say I no longer have acceptance of this, or it is clear that the person never consented because of their behaviour throughout, then it must be open to the court to say we no longer have jurisdiction, or we accept that we don't have jurisdiction. That is a proportionate way to deal with people, which is, after all,
one can see all
what
that.
we're dealing with.
That could undoubtedly be the position. I mean, that might be a perfectly coherent law. The question is whether it's the law identified by the draftsman of this regulation.
Well, I say it is.
So there are various alternative ways of looking at it, depending on which of your various submissions we accept. Suppose for a moment we accept the view that the court is seized at the moment of the moment identified in Article 16, which is at the time when the document instituting the proceedings is lodged with the court. Now, on that analysis, assuming that there's nothing occurred prior to 2007, assuming we don't have regard in some way to the care proceedings, it strikes me that the European Court might not look at it as narrow analysis. They might look at all these proceedings together for this purpose. I don't know. But let's assume we were just looking at it in a national way, and the proceedings we're looking at are the ones that began in October 2007.
Yes.
Now then, the moment under Article 16 would be when? It would be either then, would it, or the date identified by my lady.
At the time the documents instituted the proceedings, or an equivalent document is lodged with the court. Is that what my lord is referring to? Well, I can't...
That would be October 07, would it?
That's when the court is first seized in the sense that the documents are filed, but it does not cover acceptance. It doesn't
I'm not on
become anywhere
acceptance.
near...
I'm on the moment
Right.
of seizing.
Well, the moment
on the hypothesis that on the true construction of the article, we're looking for a single moment. Now, I know you don't accept that, but assuming that we're correct, contrary to your argument, then we need to identify what that moment is. And the moment is that identified, as I see it, speaking entirely for myself, by Article 16. So we have to look at the moment when the document instituting the proceedings or an equivalent document is lodged with the court. And that was in October. 31st of October 2007, or maybe a day or two later.
Yeah.
Is that right? So on that hypothesis, we would be focusing only on the question whether there had been an acceptance
at that time.
At that time, and only at that time, and anything that happened subsequently would be irrelevant. So for jurisdiction to be identified at that moment, the agreement has to be made at that moment.
At that moment.
And now, what is the evidence about that?
There is no agreement, nothing.
Yeah, that's why in Bush and Bush, the Court of Appeal
Yeah.
said that the paradigm case
Absolutely.
was prior agreement.
Yes. Yeah. Express a expressly. So,
So on that footing, you say there
the
could be no-
documents are lodged, and the very sort of looking at it the most practical way, the documents are lodged, including a document that says, Mr. and Mrs. X expressly accept the jurisdiction, or, this is the jurisdiction they want to be used, which is more in keeping with Article 12.
So is there any evidence? Let's assume for the moment that the parties to the proceedings are only the parents.
Yes.
Is there any evidence that they had, at that moment, expressly accepted,
None.
in an
Not in
unequivocal
this
or
case.
any other manner, the jurisdiction of the
No.
court?
Not in this case.
Yes, but season and jurisdiction don't necessarily have to be simultaneous events, do they?
Well, no, because it's open to parties to come along after a case is filed and say, in many instances,
That's
I
true,
don't- you
but
don't
this
have
jurisdiction.
jurisdiction
That's
for-
true, but this jurisdiction depends upon the mother bringing the matter within Article 12(3)(b).
yes, it does.
So they've got to show an unequivocal agreement at that moment.
Which there wasn't.
Well, do they? The court can be seized of the proceedings under Article 16, and then under Article 12(3)(b, surely, if both parties come to the court on foot of a summons or whatever, and both submit to the jurisdiction, that will satisfy 12(3)(b, won't it?
But that is
Well,
a
I'm
different
not sure.
time from the time my
Yes,
Lord
quite.
saying when. Yeah.
Right, I do recognise that it's a different time, and I'm asking the
So
question.
it means
Well, my
there
point
isn't
is that
our time.
it's at the time the court is seized that the agreement has to be taken place. So if you read it, the jurisdiction of the courts has been accepted expressly or otherwise in an unequivocal manner by all the parties at the time the court is
Well, it
seized.
is. Well,
Now, if that is an identified moment, namely October 2007, then that is the moment at which the person asserting jurisdiction has to show the agreement.
But how is the court to know?
court
I'm not an expert in these proceedings, but you have the initial application,
Yes.
which is the Article 16 point. But if I was a judge, I would need to know what the other party's position
Of course
was.
you would.
And so there has to be some further step. It may be, in response to the initial application, the tendering of the unequivocal agreement. But the article refers to not accepted expressly, but otherwise in an unequivocal manner. So it's not tying the situation inevitably to a written acceptance, which would be quite
acceptance,
unreal
yeah,
to
yeah.
tie it
No,
to that.
it's
So
not.
you are entitled to look at actings, and I would have thought that the paradigm case of actings would be the response you get from the other party to the application. Now,
The difficulty about that is, with respect, that that, on one view of things, is too late.
Well,
And that if you want to, you've got to get your agreement before the court is seized. And if you don't do that, there's no jurisdiction. And that would be the argument.
If you substitute moment for time, I could understand that argument, but surely the purpose of interpretation of the article must mean that the court has an opportunity to investigate the question of whether there has been a submission to the jurisdiction.
Well, that was why I was asking the question on the hypothesis that you identify a moment.
Yeah.
I quite see that if it is a continuum of time, and that is, it means at any time during the whole period that the court is seized, then you get a different result.
Well, there is
Well,
a third
that's-
alternative, if I may respectfully say so, and that is that continuum of time until it has become
Yes.
clear what the party's position is.
Well, you'd have to read
and
words
that,
into it.
that I would have thought in the common law position would be the way you address issues of jurisdiction. If in an ordinary action outside this particular regime, the opposing party comes in, says nothing to the contrary, and simply lodges the documents opposing without any kind of protest, you would regard that as an acceptance of the jurisdiction of the court.
On the face of it, yes, you would.
And the court has then got both parties before it and is then fully seized, if I can inject a word which isn't there, and everybody knows where they are. Otherwise, while I absolutely understand the precision of Lord Clark's approach, it does seem to me to be tying it very narrowly to a situation where parties have got together before the application is made, and the applicant can then put in, together with the application attached to it, an express agreement or a narrative that explains why agreement has been reached.
And there may be situations where that happens.
But it's very unusual if you have a dispute about these kind of issues that parties are going to be able to get into that kind of agreement.
I quite see that the law could be that, but you'd have to add a gloss, with respect to my lord, to the to Article 13, 3B.
I mean, Lord Clark's way of putting it could be supported on this basis, that there are two principal forms of jurisdiction under this regulation. Habitual residence of the child at the time the court is seized, and matrimonial proceedings. Those are the principal ones. This is a rather exceptional one. And where the child is not habitually resident, we want an agreement from the parents.
Well, it could
And
be.
not merely just participating in proceedings.
No, quite. We want an unambiguous, to use another word, an unambiguous but a similar word.
And it's supported by the expression "at the time," which is used in twice. It's used in Article 8.1, it's used in 12.3b, and
12.1b as well.
12.1b, and in 16. And is used in, the French has it at the date,
Yes, at the date.
and which is inconsistent with a continuum.
There is, of course, a sort of another point, which may or may not have anything in it at all, which is that one can distinguish what the state of affairs is at the time from the evidence required to demonstrate it. And if what you have is an application that's made to the court, you may, of course, accompany it with express agreement, a document. Actually, that's
Yes.
not really provided for in the rules.
No,
but,
no, it's
but
not.
Statements and things like that are not supposed to be filed along with applications, but no doubt there are ways of getting around that sort of hurdle. But supposing that you're not limited to an express agreement filed with the court at the time as the only evidence that's acceptable of this acceptance, you could draw inferences from the reaction of the other party to the official document. If that person comes along and participates in proceedings, well, that may indicate that may be very good evidence of his acceptance.
But it would have to be evidence of a pre-existing acceptance.
It would have to
If
be
it only
evidence of his forgive me, it would have to be evidence of his acceptance at the time when the application was lodged with the court.
Yeah.
Absolutely.
But in many cases, he'll be unaware of the application.
Yes.
Well, fine.
It's
Well, he was.
But were he to know that, he would accept it. This is... Anyway, all I'm seeking to do is that the requirement and the evidence needed to prove it are two separate things.
And it's a bit unreal in a case of this type where both parents are resident here to require a separate unequivocal acceptance of jurisdiction by somebody who's here in any event and will have thought that he is subject to the jurisdiction.
Yes. But even if one accepts that the moment that the court is seized is the moment, and one looks at it from that point of view, I would say in this case, there is no evidence that he unequivocally accepted the case. Certainly at the beginning, he wasn't represented. The first time that he appeared at court, it was in person, and his use of language is very limited. And to impute acceptance at that point when the court, as it were, becomes fully seized, and I know that that's not the correct terminology really, but to impute that from at the first opportunity, at the first time that the court had to assess acceptance would be wrong. The first time that they had to assess acceptance, as if one's looking at it, the first point in time is when both parties appeared before the court unrepresented and Mr. I had no interpreter. And so you couldn't say that it was an unequivocal acceptance, and that was the first opportunity that the court had to assess that situation. But if you take, sorry.
It would roll forward to the conciliation hearing when he did have an interpreter, would it?
But even then, I think the acceptance of jurisdiction, surely the unequivocal, unambiguous acceptance of jurisdiction has to be more than having an interpreter. One has to have had an opportunity to consider it with somebody who may or may not know about the limits of jurisdiction and what is in the best interests of their client as far as jurisdiction goes. And I have to say, right from the very beginning, sorry?
I'm just trying to see how this procedure can actually work. I mean, the ideal situation would be, if my noble learned friends are right, and particularly what Collins said in Bush, if the paradigm case is an express agreement which would be entered into before the application is made, I would have thought that the proper course to follow, the correct practice, would be for that agreement to be tendered together with the application at the outset, and parties would be told that that was what was expected of them. I'm sorry?
Then there could be no argument.
Absolutely so. But the form, I don't think, tells the parties that that's what they have to do. It's perhaps a pity that they're not alerted to that, but it could be that the applicant could either, if there was a form, would be expected to lodge it together with the application, or alternatively set out in the application the facts which she says, or he says, demonstrate the unequivocal agreement.
Yeah. Well, I think if my lords decide that Brussels 2 does apply to cases where children are not resident in this country,
yes,
people will be quite quick to develop such a way of dealing with the case. But we're not dealing with that here. We're dealing with a situation where that kind of provision wasn't made, and where I say that the first respondent cannot have been said whether he attended at court and spoke to the conciliator and the order was made by conciliation. And of course, my lords and my lady will be very well aware that at conciliation appointments, the orders can only be made if by consent.
Yeah. The whole thing is so unreal. I'm sorry I interrupt you again, but because nobody had applied their minds to Brussels 2 at all at the time we're talking about it.
Well, that's the difficulty with having the seizure at the first moment that the court has the case in front of it with the documents and both parties. Unless there is an absolute, unequivocal, yes, we both want this. It's not just enough to say, well, you know, I'm here. It has to be unequivocal. It says that, unambiguous. It means that. And so in the face of this case, it wasn't there at the first opportunity. Because the only other way of imputing it would be to say later on, after he'd been to court several times and his counsel filed a document expressly accepting jurisdiction, that's when it's accepted, but that doesn't fit in with the provisions of the regulations, my lords and my lady.
Yes.
There would have to be some real indication of willingness. If we take the first moment of time being when both parties are before the court.
I suppose your best point, really, assuming that we do take one moment of time, contrary to your primary submission, if one looks at the other side's argument about the unequivocal acceptance, all the events are post November 2007?
Yes.
Almost.
Well, most of them are. But if you don't take, I have, my other argument, of course, is that I would say he never unambiguously accepted jurisdiction, even in the face of his document. But that, of course, doesn't fit in with my Lord's point about when the court is first seized in the moment of time. And then there's the argument, and I would say it's a live argument, about a party coming along and the court being seized of a case that now has 3 parties, or being seized of a case that now has 4 parties. That's a moment of time when that case, even though it's a case that's already in existence.
The father's application in 2003, made under Section 13, was...
2003, sorry, my lord.
yes, the permission to remove.
Oh, yes.
That was made under Section 13, but that it's still... is it still a Section 8? It's still a Section 8 order, isn't it?
They made a Section 8 order, and it would
Yes.
always be a Section 8
And
order.
the mother's application in 2007 was also a Section 8.
Yes, and that would be within private law proceedings as opposed to specified public law
Now,
proceedings.
isn't it rather artificial to regard those as 2 separate proceedings if they're in relation to the same child? May have different numbers on.
Well, I don't think so. I don't think it's artificial. The circumstances are completely different. The child's living in a different place with different people that are intended to be the permanent carers of this child. It is a different case.
Isn't it difficult, Ms. Russell? I think, because obviously once a child's future has been put before the courts and orders made, in a sense there is always the continuing power to vary those orders, to substitute them for new orders. It is not the end in the way that civil litigation comes to an end when the court makes an order, it's unsuccessfully appealed, it's enforced and so on. Children's cases are not like that. But at the same time, the regulation clearly contemplates that there will be discrete pieces of litigation in relation to children. All the jurisdictional bits of the law accept that, so that you can have one set of proceedings about children and then another set of proceedings about children. And it's difficult. One can clearly distinguish the care proceedings, which were initiated by the local authority, to which the local authority and the child were automatically parties, and which concluded with the making of the residence and supervision orders. Nobody would suggest that the local authority would automatically become a party to any subsequent application made to vary or substitute a new residence order. So one might suggest that that was a new set of proceedings. Query the father's application, which related to the residence order, but obviously, again, I don't suppose he involved the local authority in making that application. I don't suppose he wouldn't. Everybody, it is taken for granted, is it not? The guardian ad litem drops out of care proceedings when they are concluded and has to be reappointed if a further application is made within specified proceedings. That's one of the problems. And so the father's application, although we can argue about whether Section 13 is what it's under, is definitely for a Section 8 order, basically, and is a new set of proceedings. But is the mother's also a new set of proceedings?
Well, I would say yes, it is.
Yeah.
Because, I mean, in a way, it would become unwieldy. Not in a way, but for all practical purposes, in a sense, it would become unwieldy. Cases involving the same child are always treated as the same case, particularly when they arise out of proceedings although they're still under the Children Act, are under a completely different party from that, and where the court is considering different issues, and the child isn't automatically represented.
Could I just ask you this? When the do we have the document, a document evidencing the father's application for permission to remove Q permanently from the jurisdiction in the bundle?
I don't think it's in the
Do we have any of the documents relevant to those proceedings?
only the order.
Could you just, I wonder if you could just give it But is it your case that those proceedings fall within the regulation at all?
Which proceedings?
Well, the proceedings which included the proceedings in which the father applied for permission to remove Q from the jurisdiction.
How come the child was living here? There's no dispute about that he lived here.
Well, they can fall within the regulation.
They can fall within the. Why wouldn't they fall within the regulation?
Well, when did the regulation come into force? We looked at that.
Ah, yes, but that's
yesterday.
March 2005.
Can I ask you this question? Let's assume that the regulation had come into force. Would they fall within the regulation? Because we're concerned with what the true construction of this regulation is in a more general way. I can quite see that the facts of this case do bedevil the thing somewhat because of the fact that the regulation only came into force halfway through, as it were.
We right from the very beginning, because the father's application for a residence order for permanent removal were still within the care proceedings, because the orders were made under the auspices of that.
Well, maybe, but if one looks at this through a European
No,
perspective.
they weren't, and they can't have been.
Yes,
So they're private law proceedings.
They're private law proceedings, fresh private law proceedings with a new FD04 number.
Yes. And they're within the definition of parental responsibility in Article 2.7.
They would have been covered by the regulation.
well, they would have been.
And on what basis would they be covered by the regulation?
The child.
I mean, assuming it applied.
Well,
I do take the point it didn't apply. But maybe the previous regulation applied.
Well, they would be covered by the general rule in Article 8.
Yes.
The courts of the member state shall have jurisdiction in matters of parental responsibility over a child who is habitually resident in that member state at the time the court is seized.
Yes.
So that if the regulation had been in force, it would have applied and Article 8 would have given the court jurisdiction.
Did the previous regulation apply?
no, because it dealt primarily with matters of parental responsibility arising out of matrimonial cases.
Yes. But apart from technicalities of English procedure, how is it that once the court has exercised its powers in matters of parental responsibility on the initiative of the father in allowing the child to go outside their jurisdiction, how is that, looking at it very broadly, not to be treated as the same proceeding in which the mother then subsequently asks for different orders?
Because I would say the regulation doesn't apply, because the child by this stage is habitually resident in another country.
But that's the outcome you wish to have, rather than answering my lord's question.
Either the court continues to be seized throughout, including a time when no orders or applications are sought and nothing is being considered by the court, yet it continues to be seized by the matter, or the court has to be brought into the case again and is seized again with the matter under different facts. I mean, it doesn't seem to me that courts can remain seized of a matter that isn't even before them in any shape or form.
Well, it's not so much a question of seizure as agreement, unequivocal agreement to accept the jurisdiction of the court. And one possibility is that one actually has an express written agreement between the parties at some earlier stage. And let's assume it was there in September 2004. One had actually a document which they both signed saying we accept the jurisdiction of the English courts in regard to our parental responsibility in regard to this child. Not tied to any particular proceedings, it's just simply accepting the jurisdiction of the court. Now, if it was there, would it have to be renewed, or could it still survive so long as nobody had resigned from it?
I think it would have to be revisited. I mean, I don't
Why?
think that it would bind the court and the parties until the child reaches majority.
Why not?
For the court to consider.
I'm very puzzled because the father got the order for permission to remove the child on the basis of an undertaking to return the child to the jurisdiction when ordered to do so, and also made provision for the order made provision for interim contact with the mother.
Leading up to the child's...
Yes. So then the child goes abroad. I repeat my question. It may be that under English rules of procedure, you have to start anew. I'm surprised you do, but it seems that the mother has to start some new procedure. But looking at it broadly, they are the same proceedings, aren't they?
Yes, they are.
Absolutely the same.
Looking at it at its broadest, one couldn't argue otherwise. It's the same child, it's the same parent.
Well, I wonder whether one even has to look at it broadly. The order that was made releasing the child contemplated his return to this country, if required.
Yeah.
Well, that in itself has the potential for, as you say, revisiting. I mean, the court can be called upon to give effect to the undertaking or require him to implement the undertaking that he did.
But it is not the same as unequivocally accepting.
Oh, no, we're on a different point from that.
We're on a completely different point.
This is the question about whether one needs to have a broad approach in order to say that they're the same proceedings. And I'm positing with you that perhaps you don't even have to have a broad approach, that these proceedings carry within them the potential for further applications. And it may have a different record number, it may involve making a new application, but essentially it's the same proceeding.
It may be that one of the most important points in this case, as far as practice is concerned, is what is the continuing effect of an undertaking such as that given by the father in a case such as this, which is something about which I have been worried for a very long time.
Indeed, I'm afraid that the practice is grown up, particularly to, and this is a complete aside, but particularly to encourage consent orders in difficult situations such as these, to accept undertakings for jurisdictions where orders can be enforced. And one questions whether that's the correct way to go about things, but that's the practice.
So here, if this regulation had been enforced, the jurisdiction would originally have been under Article 8. Is that right? Now, there's nothing in the regulation that provides when that jurisdiction ceases. CF Article 12. In Article 12, there are some express provisions about when the jurisdiction comes to an end. Now, there's no such provision in relation to Article 8. So why does not one treat why would not, if the article applied, why would not the European Court at least treat, or for the purposes of the regulation, treat everything that's happened subsequently as part of the proceedings which began when the first Article 8 proceedings began? Because they all relate to the parental responsibility in relation to the child. The child had its habitual residence within the jurisdiction at the time they began. There's nothing in the regulation that suggests that one should have artificial lines. The court would surely be treated, the court of the relevant member state would surely be treated as having season of the proceedings until the very end.
Miss Russell, can I help you?
Well, sorry, yes.
Well, I merely wish to indicate to you that this was meant to be helpful to you rather than the reverse. People don't always understand which way I mean, and usually I mean nothing at all. I merely want to know the answer. But if one looks at Articles 9 and 10,
Yes.
they provide for what happens when a child moves lawfully from one member state to another.
Yeah.
And the plain implication of that is that jurisdiction under Article 8 comes to an end, save
After
in the two situations provided for there.
After a set period
Which,
of time.
which would, I think, be the answer to my Lord.
Yes, I believe that.
Well,
However, the regulation doesn't apply, and we're back in Section 2 of the Family Law Act, 1986.
but nine applies when there aren't proceedings, isn't it? So that a child is habitually resident in England and then goes to France. The English court retains jurisdiction for 3 months, irrespective, and it's not talking about the cessation of jurisdiction in existing proceedings.
Yeah, it may, of course, include the situation which you're referring to, but it clearly includes a situation where there's been a judgment about access rights. You retain jurisdiction because you have made an order. That's the circumstance in which you retain jurisdiction.
Well, that's certainly
you don't retain it if you haven't.
Yes.
So it does contemplate there have been proceedings.
Although it doesn't apply to removal to non-member states.
No.
Article 9. So Article 8 would do by itself.
Article 9.2 is interesting
Maybe deliberately.
for a quite different reason, because it does show a different method of jurisdiction being established. It's by participating in proceedings without contesting jurisdiction.
Yes.
Now, that's not the approach
Well, that's not the same.
12.3.
Yeah.
I mean, my analysis wouldn't involve 12 really at all. It would simply say, well, Article 8 applies. And in fact, although Article 9 would apply, as my lady says, it would only apply if the transfer was to another member state. If it's to a non-member state, then Article 9 doesn't apply. But that doesn't answer the question whether these are still broadly the same proceedings, especially in circumstances where one of the questions is whether the father is in breach or might be in breach of his undertaking which he gave to the court in those very proceedings. They're all bound up together. And it's a bit difficult to imagine the ECJ writing a judgment saying, no, these are completely different proceedings, because that's not the way they operate. That would be a possible view.
Yeah. And what's the effect, though, that the regulation only came into force in March 2005?
Clearly doesn't apply unless it's retrospective.
Sorry, which doesn't apply?
The regulation can apply because it wasn't in force at the time.
But what about an agreement? Again, if you have an express written agreement signed and witnessed and all that, why couldn't you?
I think that it has to apply to the regulation.
Well, the court's got jurisdiction anyway. It doesn't need agreement to give it jurisdiction. The child's habitually resident here at that point.
Yes.
So
At that point,
At that point. And so whoever decided to put the former version of the Family Law Act 1986 in our bundles was obviously prescient. They realised that my lords were going to raise this very issue, and so that we could look at what the situation was in 2004.
That's it.
Prescient without necessarily knowing it.
Unequivocally.
That's very puzzling.
Well, where do we go from here, Miss Russell?
I'm sorry, my lord. I don't know if my lords would be helpful to my lords if I continued with the question of equivocation regarding consent, because of what I see my client's position was, or if it would be more helpful if we left that topic and moved on to something else.
I'm open to what everybody else thinks. I think probably you can move on, and if we feel we need to come back to it, we can come back to it. But I think we should move on to the next chapter.
Thank you very much. The next chapter that I would like to move on to, if I can, is in relation to the child's interests.
Yes, best interests.
Best interests. And I see that if the regulation applies, then the court has to consider, and the court decides that there has been unequivocal acceptance, then the court would have to consider whether or not it was in the best interests of the child to exercise the jurisdiction it says was chosen and accepted by both parents. And in this case, I would suggest that even in the face of the evidence that's before the court, and there are many issues regarding this case that have not been aired, heard or decided, in fact, at all, since the child was removed from the jurisdiction, because most of the conflict that's arisen between the parties over matters appertaining to contact have not been heard or decided by the court. But even on that basis...
issue, I'm sorry to interrupt you, but the issue one's looking at is not the full merits investigation.
No, indeed,
surely.
I'm not
You're bearing that in
I'm
mind,
saying, even given that, there is a real case for arguing that it would not be in the best interest of the child and that the court has to consider that. But from the point of view purely of whether or not this regulation applies in this case and should apply in these cases, what I'm really saying is whichever court is making the decision about whether the regulation applies, that court would have to investigate whether or not the exercise of the jurisdiction was in the best interests of the child, having gone through the other hurdles that we've already discussed in some detail. I don't know if there's any dispute about that.
In other words, a full comprehensive investigation of the best interests.
There would have to be more than just what's on the face of the documents in order for the court to make a proportionate decision about what is in any child's best interests.
But something short of
a full hearing, no, yes.
Full-blown, I see.
And what sort of factors would the court be looking at? Is it
Well,
where
the
where
court
the
would have
witnesses
to
are?
consider the effect of the on the child of a court in this country deciding issues that are principally concerned with another jurisdiction. So there would have to be a look at the balance of how much the court could do that, because it may vary very much if we're just looking at the regulation from the point of view of a regulation. It may be very easy for the court to consider what's in the best interest of a child who's living in France, because the factual matrix is easier to ascertain. But to consider the effects of a child who lives in a different country and speaks a different language, and although that may be true of France, but who is much further away, there's a different cultural matrix, there's no real strong connection because the child has lived so long in another country. Those are the kind of issues that the court would have to consider, not in all the detail and certainly not by deciding conflicts between the parents about their behaviour, but within the context of the case.
So it's a forum on convenience
forum
exercise.
non-convenience type
Exactly, yes,
exercise,
it's really
yes,
that,
in a
isn't
way,
it?
yeah.
Yes.
But it's not. It's based on this, not on the. It's based on this part, the third part, if I can call it that, of B of 12.3 of Article 12.3.
But the sort of factors one's looking at are the same sort of factors as one is looking at in deciding.
Well, my lady, I would say that that's the only way you could possibly come to any kind of decision about what was in a child's best interests. It would not be right, for example, to presume that because the child is living in, even though Article 12.4 suggests this, that because a child is living in a non-Hague Convention country, ipso facto, therefore it must be in the child's best interests. Best interests are not the same as interests. And there is also the question of the ability of the court to look at questions regarding the child's best interests, and how that could be done in a way that is in keeping with that child's best interests. For example, I would say in this case, it may not necessarily be, and it's not something I'm asking my lords or my lady to make a decision about, but in this case, one may say quite strongly that it can't possibly be in this child's best interest to be brought over to this country to be assessed, when in fact he's been living for most of his life with his grandparents in Pakistan. That's an example. I mean, it would be something the court would have to look at. And I know, for example, that his guardian feels it wouldn't be, on the face of it, a good idea for him to be brought over in his interest. So those are matters that the court would have.
But of course, there are other ways of handling that problem.
There are, but
I have plenty of recollection.
Some
things I have forgotten, but I have plenty of recollection of handling cases where the welfare inquiries were actually conducted in the case where the child, where the child was, and often very satisfactory.
Yes, indeed.
Got wonderful reports from International Social Services.
Yes, indeed. I'm not saying it's impossible.
We'd only be focusing, wouldn't we, the court would only be focusing on the issue of jurisdiction.
At this stage, it would be,
not
yes.
on what would happen at the hearing where the jurisdiction was being exercised, and whether the child should be brought back or not for the purposes of an assessment.
But I think, my
wouldn't
lord,
be implicit in the jurisdiction question, because, as my lady says, I understand it's quite common for material to be obtained in various ways from other parts of the world.
This is where the Court of Appeal's paragraphs 31 and onwards are paragraphs you'd support.
Yes.
Is that not right? I mean,
Yes,
you've got Lord Justice Thorpe saying this child has been in Pakistan for more than half his life. Any decisions are better dealt with in the courts of that region, and then he comes on to deal with the protocol. There's those sort of points.
Yeah.
And you're supporting that, obviously.
I am supporting that, and I say it's something that the court would have to do.
And
Are you inviting us to decide that, or are you inviting us to remit it, assuming we were otherwise?
I'm inviting you to decide it within the context of what you have before you.
And if you're wrong on third state, then there's not much to be said on this part of the case.
Well, I'm saying that if you look at this case objectively from the child's point of view, it's not in this child's best interest. It doesn't reflect his interests for the case to be heard here.
So you say this, you get the same result under 12.4?
That's what I'm saying.
Yeah.
Well, it's the only other matter that I had that I wanted to deal with you, and it has in fact been dealt with, which was the status of orders, and we had a discussion about that, so if I can put it that way. I didn't think it was necessary for me to address you again on that matter, but...
Do you want any more on that? No, thank you very much.
Is there anything else that I can...
Yes, could I just ask you a point about the transitional position, the effect of the fact that, on one view, this regulation only came into force halfway through, in which case we'd have to grapple with what the position was before, on the facts of this case, before the witching hour, sometime in 2005. Yeah. And would the English court have had jurisdiction on the English law as it stood before the regulation B2 revised came into force?
No.
It wouldn't.
Well, I would say...
Why not?
Why not?
It's a completely English case.
At that point in time.
But the child's moved to... Sorry.
Yeah, yes, but the child was within the jurisdiction. So
when the child... Oh, but no,
so
no,
then
of
the
course
court would have had...
Yes, of course. Sorry, I do beg your pardon.
And if what would have been the position under English law on the facts of this case if all the facts had occurred but the regulation had not come into force?
So the child had moved?
Yes, everything else had been the same, just that the regulation hadn't come into force. What would have been the position?
Well, then the argument would have been about whether or not jurisdiction could still be exercised given the passage of time. There would be an argument about where the child was living but it would be within the old legislation and not within under the regulation. So one would look at inherent jurisdiction, and one would look at. But whether, is my lord asking whether the Children Act proceedings would still subsist?
It's all dealt with by Section 2 of the Family Law Act 1986, coupled with Section 3 of the Family Law Act 1986. But I'm now frantically searching through that as to what it says about the duration of proceedings for the purposes, for the question that's being asked. It may not be a sensible course of action for us to look into that question on the hoof while you're on your feet, but everybody's got the question. Yeah. Supposing Brussels 2 revised was never there, or doesn't apply to these proceedings because we have ongoing proceedings, what is the position? The
position, I'm not trying to answer because I really do need to look at it and think about it properly, but the position would be one of the pertinent points that one would have to consider when looking at the position is that there was no continuing order regarding contact or anything else except the father's undertaking. So that, I think that would have an effect on what the jurisdiction was.
The accept might be quite a big accept, though.
But the child's still British national, so it's still jurisdiction on that basis.
Yeah. Yeah.
Well, yes.
It's my fault. I'd like to be quite sure about dates on this point. I understand from the Statement of Facts and Issues that the child left this country on the 22nd of December 2004.
Yes, that's right.
And when did the regulation come into effect?
March 2005.
March 2005. I don't know the precise date, I'm sorry.
So the child has left the country before the regulation comes in. Thank you.
3 months before.
They don't go in for transitional provisions, however, these regulations.
No, they don't.
It's also possible, which is one of the reasons why it's complicated, were one to take this view of the proceedings, which would possibly be controversial, but nevertheless, were one to take this view of the proceedings, it's possible that the Family Law Act provisions, as I referred to yesterday, are really contemplating moves between England, Scotland and Northern Ireland, and have not addressed their minds to moves between the United Kingdom and other places. It may have done, because I haven't revised it, and it's a long, long time since I was instrumental in signing the report that led to the 86 Act, for which I apologise. I've had plenty of punishments.
Well, I think we've probably come to an end of your submissions now. Thank you very much indeed. Miss Bhatia.
Thank you.
Now, Miss Charlton.
Yes. Well, can I at the outset say that there was some discussion yesterday morning about the appointment of the guardian and the appointment of the child as a party. And there was, as I recall, a request perhaps to have sight of Rule 9.5. Lords, I have brought copies of that today, if they may assist, together with a copy of the practice direction from April 2004.
Yeah.
Lords will see in Rule 9.5, paragraph 1, that it is open to the court if it is, in the court's view, in the best interests of any child to be made a party to the proceedings, to go on and appoint, subparagraph A, an officer of the service or a Welsh family proceedings officer. And that would refer, in my submission, to a CAFCAS officer, and that is indeed what happened in this case. Lords, in paragraph 5, 9.55, it is clear that that person who is appointed is then to be treated as a party for the purpose of those proceedings. Lords, the attached practice direction is of relevance in this way, in the sense that at paragraph 3, it sets out some guidance in respect of the decision to make the child a party. And it refers at paragraph 3.7 to circumstances which I would say accord to this case, so that where there are international complications outside child abduction, in particular where it may be necessary for there to be discussions with overseas authorities or a foreign court. So, my Lords, in my submission, while I acknowledge that it is unusual in many private law proceedings to have the child joined as a party, as was indicated yesterday, in cases of this type where you have got non-abduction international complications, it may well be that it is a more likely occurrence than not.
Yeah.
Was this the practice direction that had to be withdrawn because it was too broad?
I'm not aware that it was withdrawn in its entirety.
Or modified or clarified. I'm not suggesting that the particular case would have then been taken outside it, but my recollection was that a very sensible practice direction was made, and it proved so sensible that Kafkas couldn't handle it.
Lady, that may be right, but my understanding is that still cases with the kind of international complications such as this...
I'm not denying that for one moment.
I'm grateful.
No. I was merely wanting to get to the effect of the actual order that Mr. Justice Headley, I think it was, wasn't it?
Yes,
made.
it was.
And I think this, seeing the rule, clarifies it.
I'm grateful. Lords, perhaps I can set out the Guardian's position in the sense that it is perhaps not at first blush always the clearest. Lords, the Guardian was appointed, as we know, in July, although he wasn't actually allocated to this matter until September. And he provided two reports in the proceedings, one in January 2009 and one in May 2009. And Lords, they are in the bundle, the Appendix 1 at 43 and 44 respectively. And
it's the numbers there.
Sorry.
Appendix part 2.
The large appendix bundle.
Yes,
at tab 43 and 44.
43, sorry, I beg your pardon. 43 and 44, yeah.
Of course, the order of Mr. Justice Headley had provided for the children's representatives to restore the matter back before the court once the Guardian had had time to make some preliminary inquiries. The report was therefore prepared and the matter then, of course, as we know, brought back before the court in the early part of this year. But, Lords, the relevance of that report in my submission is perhaps that at page 13, it seems that the Guardian was the first person, certainly the first party, to seemingly apply his mind to the jurisdiction of the court. He has consistently since that time flagged up with the court his concerns about the jurisdiction. Lords, a position statement filed on his behalf in February was very clear that one of the first questions that the court should be asked to consider was the question of jurisdiction. And that position statement is at tab 18, again of Appendix 2, as I understand it.
Yes.
So it would seem to be clear on the face of the papers that the Guardian has consistently raised this concern. But he has been seeking the guidance of the court on the matter, and he has sought the guidance of the child's solicitor. He himself was not expressing a personal view and to some degree that remains, in terms of the question of jurisdiction, his position. At the hearing in May before His Honour Judge Barnett, the child's solicitor argued on his behalf, on legal grounds, that the court did not have jurisdiction. But my Lords will of course have seen that, in fact, when it came to arguments of forum non conveniens, the Guardian, in fact, preferred that the matter be dealt with in this jurisdiction. From that point on, the Guardian has taken the view that he was content with that decision of His Honour Judge Barnett, so took essentially a neutral stance in the Court of Appeal. He didn't seek to go behind that decision, and the position today is essentially that because he doesn't seek to go behind those decisions, he essentially resists the appeal. But it isn't perhaps at first blush the most straightforward position.
I understand from the end of paragraph 14 in your written case that you have as it were, a solution if our decision were to be that jurisdiction was in England, that an initial assessment should be carried out in Pakistan. So you're not saying that it's impossible to live with the decision to that effect?
I'm not saying that it's impossible to live with the decision. No, and in fact, I also indicate in the written case, I think probably the preceding paragraph, that he is still of the view, and this is in paragraph 13, that despite the various practical difficulties, there are some advantages, and one specific advantage in his view, to the matter being dealt with in this jurisdiction. And that is because he is mindful of the fact that the nub of the application is for contract in this country. And he is also mindful, from his knowledge of the case thus far, that this is a mother who could pose significant risks to this child. And he, on conducting a balancing exercise, has felt perhaps more confident in the courts of this country to be able to place the appropriate safeguards around any contact were it indeed to take place. They would, for example, be able to involve, if needs be, the local authority and other resources which may be able to assist.
It's interesting, is it not, that Mother has herself escorted Qadir back from Pakistan for some of his previous visits here. And I suppose the Guardian would say, well, that is an indication that just possibly some of the protective mechanisms in this jurisdiction ought at least to be under consideration, rather than leaving it all to private enterprise, so to speak.
Indeed, the Guardian has indicated in his reports that he has, because of the practical difficulties, thus far found it hard to conduct a meaningful analysis. But nevertheless, because of the background, and because of the extent to which it would appear that the mother has not been able to move on from that, he is very mindful of the risks and would be taking a cautious approach in respect of those at this point in time. Essentially, Lord, that was the reasoning which caused him to say at the hearing in the High Court that he felt this jurisdiction should deal with the matter. The matter was going to be looked at on the basis of forum non conveniens or otherwise. And that is still, on balance, his view. I should say, though, and I have tried to stress in the written case, that it isn't an easy balancing exercise. He has had considerable difficulties in this matter. He hasn't been able to speak about it. There are obviously practical considerations and difficulties in relation to the child's circumstances there and the attitude of a paternal family towards contact. So it has been a difficult balancing exercise. Lords, I hope that assists in clarifying the Guardian's position. What I don't intend to do, Lords, unless I'm required to, is deal with a number of the matters that have already been raised in relation to the third stage. I've made a number of observations in the written case, and those to some degree have perhaps been overtaken by debate, and I'm not sure there's a great deal that I can add to that at this point in time. But what I would seek to do is to address issues in relation to the voice of the child or indeed the guardian on his behalf, either in terms of jurisdiction and also in terms of best interests. And I would also seek to address, if I may, the assertion that's been made that Section 1.5 would essentially enable a decline of jurisdiction or the matter not to be dealt with because the court could make no order. Lords, the voice of the child in my submission is important, and it is important at an early stage. We have a situation where, as I've indicated at the outset, it is perhaps a more likely occurrence than not that there would be a guardian appointed on behalf of a child party in proceedings such as this. We have a situation where, in terms of consent and jurisdiction, as set out in Article 12, it is very clear that it should involve all the parties. And it is of some concern to the guardian if there is an interpretation that effectively does not enable those appointed on behalf of the child to have a voice on this point. I accept that at that early stage, one isn't looking at a full welfare evaluation. But I would say that clearly it is of relevance for anybody appointed on behalf of the child to have an input into what the child's best interests may be at that time.
And just looking back at what you showed us in paragraph 9.5 of the rule, when the court is considering whether it's in the best interest of a child to be made a party, do I follow from what you've just been saying that one of the things that should go through the court's mind is it in the best interests of the child that he or she should be made a party before I decide whether or not I've got jurisdiction? Is that what you're saying?
Indeed. And it may be, following through the debate that we've heard over the last 2 days, that, in fact, in cases of this kind, the appointment of the guardian is something that needs to be addressed by the court at the first available opportunity, so that they can then have any input into any jurisdictional decisions that may be made. Lords, in essence, it does seem inconsistent to have a situation where you can be appointing somebody to advocate on behalf of the child, but then have a system that is excluding them from very significant decisions which obviously can have an impact on the child. Lords, in relation to the suggestion that Section 1.5 of the Children Act is a way round this, I would seek to make the following observations. Because, of course, Section 1.5 would come into play towards the end of the proceedings. And that would expose the child, potentially, to proceedings, long proceedings, with the associated anxieties and uncertainties. And clearly there needs to be an earlier best interests decision. So in my submission, section 1.5 is not necessarily a viable solution.
But we're actually talking about two completely different things. We're talking about the preconditions for the exercise of jurisdiction at all, which has a range of factors when we're talking about best interests, which include practicabilities, which include where's the evidence and how can we get the evidence and so on. And then we're talking about supposing the court accepts jurisdiction and therefore, because it considers that the proceedings should go ahead, and then all sorts of process happens and the court has to decide what order at this stage in relation to the child's future is in that child's best interests. And among the options which may commend itself to the court is making no order. But nobody's suggesting that it's the only option. Nobody's suggesting that it's a solution to really the jurisdiction problem. It's just being suggested that if the facts turn out that there is no point at all in the English court making an order, because, for example, the wishes and feelings of the child are, I want to stay in Pakistan, I'm very happy here, and I don't want to be brought back to England to see mum, the court's answer may be no order. That's, but that's an example of the difference between accepting jurisdiction and how you exercise that jurisdiction.
Indeed. Lady, it may have been my misunderstanding, but I had understood that Mr. Baker was using it as a way of saying that the guardian can invite the court at the end of the day to make no order and therefore doesn't necessarily need to have a voice on the issue earlier on in the proceedings.
Well, he may have been saying that.
And my lady, what I'm saying is
he'll tell us whether that's what he was saying.
but lady, what I'm saying is that it isn't a viable alternative to allowing the child or the child's representative a voice about jurisdictional issues and that voice to occur earlier on in the proceedings.
Yes.
Lady,
But of course, if the only way of applying, if the only way of applying Regulation 12.3 is by prior written agreement before the proceedings are started, there is no way in which the guardian could be involved, because there would not be a guardian, the court would not have power to appoint a guardian, and by definition, the child at that stage is not a party. The child is often not a party in proceedings in other member states as well. The child's voice is a different thing from the child being a party to the proceedings.
Indeed.
And so one has to bear that in mind. But if the paradigm is prior written agreement, nothing that could be done to solve your problem.
Well, indeed, and lady, perhaps that is one of the factors that would stack up against prior written agreement being sufficient. And of course that comes back to a point which I believe Ms Russell raised.
Not so much being sufficient as being required.
Or required, as to how and who would then evaluate the best interests at that initial hearing. So,
well, actually, courts do that all the time. I really do object to the notion that courts aren't able to make these sorts of evaluations. There are lots of cases in which children are not represented. There are lots of cases in which children are not parties. There are even cases in which there aren't welfare officers' reports. And there certainly used to be in the olden days. And I'm sure that's the case in other places. So if we're taking a Euro-wide look at this, rather than an even Anglo-centric look, because the way in which they represent the interests of children in Scotland is completely different from the way they do it here. Can't make that assumption.
Indeed, and lady, I wasn't suggesting that the courts couldn't undertake that evaluation, but in my submission, if we are dealing with situations where somebody is going to be appointed to represent the child's interests, it is often helpful for them to be able to have some input and to have that input at an earlier stage rather than to come in and then have perhaps a number of concerns that they would seek to raise that can then not be considered. Lords, as I indicated, I don't intend to go over ground that's already been covered. I don't know if I can be of any further assistance on behalf of the Guardian.
Well, we have had a chance of reading your written submissions, and you've covered a number of the points there, which have, of course, been fully debated by other people.
Indeed.
I think it's something, if you had any other points of disagreement or encouragement one way or the other, we'd like to hear from you.
Could I just ask you one question? On the hypothesis, this relates to Article 12(3)(b), on the hypothesis that at the time the court is seized, on the face of it means first seized. I know that there are arguments the other way, but suppose that's the case. In a case, the difference between little b in paragraph 3 and little b in paragraph 1 is there the agreement is simply that of the spouses, whereas in little b it's all the parties. And one view might be that the draftsman contemplated, at any rate, that one of the parties would be at least the voice of the child and maybe the child. Now, is there any way in which one could construe little b as only coming into force, if you like, or only giving rise to the relevant seizing once the child is made a party?
Lord, I think not. I, for my part, would think the options are that if it is to include the child, then the seizing needs to be interpreted as having at least some degree of a continuum about it, so that it isn't simply the moment, it continues at least for a period. I know there was some discussion about that earlier, and it's difficult to know where cut-off points could come, but I think there are difficulties otherwise.
Thank you.
Do you have a position on whether the relevant proceedings started in 2003 or 2007?
For my part, I think I would suggest 2007, in the sense that while I acknowledge they are all proceedings in relation to the same child, to consider a number of applications in respect of one child that could take place over a significant period of time, all as one set of proceedings, is, in my submission, something that could well be misleading. The initial orders back in 2003, of course, were a residence order, the order for the leave to remove from the jurisdiction. This is an application that the mother is making, asking the court essentially to survey fresh ground. And in my submission, it is, as a result, a separate set of proceedings. To use an example, or to consider an example, if a relative, a grandmother, for the sake of argument, sought to make an application in respect of the same child, that would be viewed, one might consider, as a separate set of proceedings, a different party, but yet it's still a Section 8 application in respect of the same child. So, on balance, I think my view would be that I would see these proceedings as separate from the earlier proceedings and starting in 2007.
But presumably the answer to that question wouldn't depend upon whether they were in fact in separate proceedings on a narrow English procedural basis, would one? As a matter of construction of the regulation.
Possibly not.
So one has to have some broader test than simply asking the question, what number do the proceedings have, and was it a different number from the other lot?
I think it needs to be looked at in more detail than simply the case number. That certainly I would agree with. But I equally think that to say that all proceedings are under the same statute in respect of one child, potentially throughout the duration of his minority, should therefore be seen as one set of proceedings, is misleading and is wrong, and I don't agree with that.
Who would have been the parties to the order that the father obtained in 2003?
The leave to remove order?
Yes.
that, I'm assuming, would have been just the mother and the father. The local authority would no longer have been a party. I think there was a supervision order in force, but nothing
Do we
more
have
than
the
that.
order? Do we have the order?
Yes.
I think is it in 25? 20, I'm suggesting it's in 25.
It is in 25. Upon hearing counsel for the applicant, a second respondent.
Oh. There we are. Yes.
The second respondent may have been the local
I
authority.
think that must be right.
I do apologise for
Yeah.
Yes.
I do apologise for interrupting, but Ms. Bhatia, who was there, tells me that they were there because they were helping, as it were, with proposals regarding contact.
So that's the local authority.
Yes,
They
they are the applicant.
Sorry, forgive
Sorry,
me.
no, not at all.
By that stage, the supervision order had just run out, had it? Yes.
Contact
Yes.
pending removal.
Yeah.
The supervision order, they were supervised under the supervision order.
Sorry, beg your pardon.
They were supervised under the supervision order. The supervision order was ending before
Right.
the removal.
The supervision order was going to come to an end before Q was removed from the jurisdiction, and there were problems over contact and supervision of the contact prior to removal, so they were still involved to that extent.
Paragraph 4 seems to suggest some supervised.
Yeah.
But definitely it was supervised, yes.
Yes, because supervised contact is different from a supervision order.
Of course. No, but I'm explaining, sorry, why they were involved.
No, I merely...
But thank you.
But the Guardian does not appear to have been involved.
Well, not in the face of the order, but I wasn't there.
No, lady, can I say for the sake of clarity that the Guardian who is now appointed is not the Guardian who was appointed in the public order?
Of course, I think I'd made that assumption somewhere.
When
Having read the
I'm going
document.
to try and get the same person.
can I get my dates right? When was the Guardian you represent appointed?
This Guardian was appointed in September 2008.
Right.
When he was allocated that, of course, the full
Yes.
appointment by order of the court was July 2008.
I see. Yes.
But he was not involved as a public law guardian in these proceedings. It was a different guardian.
Yeah. Right. Well, I think you've probably completed your submissions. Mr. Secretary, I think it'd be convenient to rise now, and we look forward to hearing you at 2 o'clock.